I should say this is a bit of a special occasion for our lunchtime seminars, because it's my pleasure to introduce Justice Weinberg, who's, well, we're very fortunate to have him with us as our Inns of Court Judicial Fellow this term. Justice Weinberg is a Justice of Appeal at the Supreme Court in Melbourne, in Victoria. And he'll be giving an evening lecture, and I must get this right, 6 p.m. on the 21st of November. And that will be on the future of the jury in criminal trials and the problems of jury directions. But today he's speaking on modern drafting and the criminal law, and does codification work. So I shall hand over to you.
Thank you very much, Jules, and thank you all for coming today. It's a great honour and privilege to be back at the Institute. I said in the note that I filled in about what I was going to be doing here that I'd spent 6 months at the Institute of Advanced Legal Studies in 1979, before many of you were born, and I thoroughly enjoyed my stay then. I was an academic in those days. I was an academic for some 15 years teaching criminal law and evidence, but also practising part-time at the bar, and eventually the lure of the bar became too strong and I went to the bar full-time. And just by way of background, I've been defence counsel. I was the Commonwealth Director of Public Prosecutions for 3 years. I was on the Federal Court, which does no criminal work at all. It's an entirely civil court, for 10 years. And then I returned to my first love about 8 or 10 years ago, Court of Appeal in Victoria. So I'm actually quite old, and I've been doing this for a very long time. The next thing I want to say is this is actually the 50th anniversary of my first acquaintance with the criminal law. As a young student, I started at Monash University, and I recall very clearly that the criminal law that I studied was basically the common law of England. And many of the cases that we looked at were English decisions, appellate decisions, and so forth. We started with a vigorous analysis of the Queen against Dudley and Stevens, the famous Mignonette case involving cannibalism and so forth, and I was entranced by the criminal law right from the very outset. The developments that have occurred over the years since then is that the common law has all but disappeared in my country in terms of the criminal law. We have consolidated and consolidated and consolidated, and then we've codified and codified and codified, so much so that the work that we do in the Court of Appeal consists of statutory interpretation and nothing else, basically. There's a little bit of residual common law, but not very much. The other thing that has changed, of course, is that whereas in my early days we focused heavily upon English cases, English case law, once you adopted the Human Rights Act in 1998, or enacted the Human Rights Act, we found that so many of your cases involved human rights which had no application to our jurisdiction, that English cases became less and less useful, and so I sold my authorised law reports, as did many of my colleagues, and we very rarely got back to reading English cases. Then along comes Brexit, and maybe English jurisprudence in the future will be pertinent again. And I spent this morning reading the judgment of the Divisional Court, which is fascinating from a constitutional perspective as well, and I urge you all to do that. All right, well, my topic is the criminal law codification, and codification's been around a very long time as far as the criminal law is concerned, and the United Kingdom is really at the epicentre of the codification movement. If you go back to the 1830s, you'll find the earliest developments towards codification following on from Jeremy Bentham's work. 1860s, Stevens Code drafted and picked up largely in India, picked up largely in Canada, picked up in 3 Australian states, not picked up in England, curiously. In the United States, codification, model penal code, largely the work of the great Professor Wexler in the 1930s, a code that's been picked up and adopted in, I think, 39 states out of the 50 states in the United States. What is it that's brought about this movement towards statutory consolidation and towards codification particularly in my country. You've always had in England, I'll say England, I mean England, Wales, I mean the United Kingdom, strong academic support for codification. From the time of, I suppose, the 60s, there have been moves towards codification of the law. I had the great privilege of being taught by Rupert Cross at Oxford, and he was a strong proponent, of course, of statutory modification of the criminal law. He concluded that the common law not only was past the age of childbearing, but was full of, replete with deficiencies and so forth, which only legislation could overcome. He was also, I think, a strong supporter of ultimately a codification movement. That developed in the 1980s in England in particular, as we know, and under the work of Professor Smith and Hogan, J.C. Smith, together with Professors Dennis and Grew, and they produced work of immense value, which culminated in a draft criminal code. So you actually have a criminal code available to you, produced by the Law Commission in 1989. It is, and you'll be surprised to hear me say this, it is a fairly short and succinct code. It goes for more than 100 pages, like 119 pages, but by the standards of my country, it is literally a pimple on the elephant's rear, if I can so describe it, and I'll explain to you why I say that codification has a tendency to expand in extraordinary ways. But the academic movement in England, by and large, has been a strong proponent of codification. Professor Ashworth, Professor Samuels, Professor Smith. It's difficult to find an academic who will speak out against the desirability of codification. And why codify? Because it is said to make, and the Law Commission says this, make the criminal law more accessible, make it more coherent, consistent, transparent. You can use all the adjectives that you like. The proponents of codification in the Law Commission and the Law Commission report also picked up what one might call the straw man theory. They erected a series of arguments against codification and knocked them down in the space. The actual movement for a general codification of the substantive law in England and Wales has gone nowhere. I learnt last week from Professor Ormerod in his talk on codification that there is a major task force engaged in the process of codifying the law of sentencing in England. And I had a few things to say during the course of that talk about that exercise, and I'll say some more in a little while. I'd like anybody who wants to interrupt or ask a question to do so at any stage. Please feel free. This is a very informal chat, and even if you can't get your question in during the hour that we've got, I'm happy to be here for the next 6 weeks or so. I'm happy to talk to anybody in detail about the sorts of things that concern me. All right, so 50 years of work in the criminal law. What has it led me to? Codification. How has codification worked? Can it be made to work? The theory is excellent. The idea that we take the common law with all its faults and deficiencies, built around, inevitably, the problem that the appellate courts deal only with problems as they arise, and so everything is done in a non-systematised way. We resolve one particular problem. For the purpose of that case, the theory is that you don't decide more than is necessary to decide. You don't write textbooks. That's sometimes something that's difficult to resist when you're a judge writing a judgment. You have this desperate urge to expound on things that might assist, in inverted commas, trial division judges, but we try to resist it as much as possible because we know we haven't heard full and proper argument in a concrete case. So that's the way the common law develops. And the common law has other disadvantages. It's retrospective in operation, necessarily. When you redeclare the common law, you're saying that earlier decisions were wrongly decided, and somebody is going to suffer as a result of that, retrospectively, if you like. In my country, we are a federal system. And a federal system, of course, means that we have a federal tier of government and the states each responsible primarily, theoretically, for criminal law. So criminal law is state-based. At least that's the theory. And when I was Commonwealth Director of Public Prosecutions between 1988 and 1991, the Commonwealth criminal law, federal criminal law, was a very small component of criminal law generally. It didn't deal with crimes like murder or rape or theft or matters of that kind. It dealt with the boutique crimes, if I can put it that way, crimes against the government, crimes that had a federal connotation, and constitutionally that was all that the Commonwealth could be interested in and would have enacted. And it was small, but there it was. It tended to defer largely on matters of procedure to the states, so that insofar as the Commonwealth was silent in its legislation, and the legislation was very, very briefly and succinctly expressed, the theory was that it would be picked up and applied in each state in a different way, so that we had the Victorian sentencing provisions were applicable to Commonwealth offenders who were being convicted under Commonwealth law but sentenced in accordance with Victorian sentencing practice. This is obviously unsatisfactory at a theoretical and practical level, because people who commit an offence against the law of the Commonwealth of Australia should be dealt with in broadly the same way around the country. So this led to a movement which was a movement towards systematising and unifying the law, and it really was the impetus for codification in Australia, the codification movement from about the mid-1980s. It started with sentencing. Let me tell you how this all happened. It's an interesting story. I was director at the time. We knew nothing about the fact that the Commonwealth Parliament was planning on introducing sentencing legislation for federal offenders. On a Friday afternoon at about 2 o'clock, I was contacted by the Attorney General's Department to tell me that this was in the wind and we would get the draft bill over the weekend, and could we have comments by Tuesday. That was the way in which legislation and the legislative process was conducted. It was a series of amendments to the Crimes Act of the Commonwealth, Crimes Act 1914, Part 1B as it was called. They introduced these provisions. We looked at them. There were obvious faults with them, but none of our concerns were taken seriously, and the legislation went through. And of course, what we said about it at the time was interesting and right. For example, the legislation thought that it would be a good idea, or Parliament thought that it would be a good idea to set out the principles of sentencing. And it did. It said, for example, these are the criteria which are to be taken into account by a judge when sentencing. This is codification, bear in mind. This is a code. And what did it leave out? Guess. It left out general deterrence. Of all the factors that one would have thought would feature as among the matters that should have been taken into account when passing a sentencing code, general deterrence would have been at the very top of them. Specific deterrence was there, but not general deterrence. And so we had a whole series of cases having to be determined as to whether Parliament had deliberately intended to omit general deterrence as a relevant sentencing factor. It just illustrates the way in which there is a danger associated with codification, because you will always leave something out or fail to deal with something. And it took until 2015, some almost 25 years or so after the legislation was enacted, until Parliament amended the Act to insert general deterrence as a sentencing factor. The courts had sorted it out in the meantime. The courts had said it's implicit that general deterrence is there, it's too obvious, and therefore they read into the statute a requirement that general deterrence be taken into account. How did they do it? This is actually quite fascinating. They took a provision. This would have to be, I think, the worst drafted provision ever enacted anywhere in the Western world. I'll read it to you. This is section 16A of the Crimes Act 1914, introduced in 1988, as I say, the weekend's notice. This section tells judges who are sentencing offenders this: in determining the sentence to be passed or the order to be made in respect of any person for a federal offence, a court must impose a sentence or make an order that is of a severity appropriate in all the circumstances. Now, can you imagine any judge having to make sense of that? Is the converse that you are not to impose an inappropriate sentence? In other words, we've been told you must sentence people appropriately. Well, that's a very helpful statement And at least we're able to use that provision to say, oh, well, implicit in that, through a bit of legerdemain, a bit of hocus pocus, judicial interpretation, we're able to say, well, that implicitly brings in general deterrence. It's not true, but that's the way in which it's been dealt with. So this was the impetus, if you like. Yes?
May I ask, was it a deliberate policy choice to leave out general deterrence in legislation, or was it simply a mistake?
It was a mistake. It was purely a mistake. Why was the mistake made? Because those who were drafting the provision simply omitted to include it without realising that the failure to state it expressly might lead somebody along the way to argue that this was a deliberate legislative intent to exclude general deterrence as a sentencing factor. I pose it only as an illustration of one of the difficulties associated with codification. That once you embark upon a code, you've got to be sure that every word that you choose is appropriate and that it will not have unintended consequences. I'll give you some other examples in a little while.
I'm just wondering if it was an exhaustive list of sentencing criteria?
No, it wasn't. The statutory criteria said include, and there were a series, and that again left open the possibility of others, but it's quite significant when you have, you know, specific deterrence as one of the factors which are to be taken into account, and general deterrence is not mentioned at all. It's quite significant. And you will inevitably conjure up arguments and get submissions about whether or not this is right and proper and so forth. Uncertainty is the worst feature of any code. If a code is intended to produce not just accessibility but certainty, you have to be so very careful about the language that's being chosen.
And nobody raised the point during
Oh,
the
it was raised. It was raised within a year or so.
Well, ignored by the legislature.
Yes, they did nothing about it because the courts had fixed it up. The problem had gone away because very early on the courts had said, oh, this is blindingly obvious. It's either an omission by the legislature or you can find it implicit in 16A1 or there's a non-exhaustive list that it's too blindingly obvious to contemplate.
So it wasn't a problem, really?
Well, it wasn't a problem because the courts fixed it up, but it was a problem in the drafting. It was a problem in the way in which the code had been put together. And that's my point, that codification is not a process that should be conducted quickly over a weekend, nor do I suggest that the work of the Law Commission in England is anything like that at all. It's very high quality work. I want to talk a little bit about what's happened to the criminal law over the last 20 or so years, and I've spoken about the federal criminal law in Australia and how it was a boutique branch of the criminal law in Australia. Well, the statute was very small when I took on the job of Commonwealth DPP. We did tax fraud and we did drug cases and we did cases of that kind, but we didn't deal with general criminal law at all. In 1995, the Commonwealth of Australia, once again, again the villain of the piece, decided that we needed a comprehensive criminal code, indeed one that was a model for all the states in Australia to follow. And they had a committee that did on this occasion sit for 2 years and produced what was called the Criminal Code Act of 1995. And they had before them examples that they could work from. They had the Model Penal Code of the United States. They had the Law Commission's draft code and work done by English academics and so forth, and various other codes. The Indian Code, we had the Queensland Code, the West Australian Code, which were based on the Griffith Code, on Stevens Code and so forth. So there's a lot of examples that we could borrow from. And we started off, as modern codifiers tend to do when they're codifying substantive criminal law, with what was called the general part. And this comes from Glanville Williams, of course. The general part. Well, what are we going to codify? We're going to codify the physical aspects of a crime, what used to be called the actus reus. We no longer use Latin in Australia. But it's the physical aspects of the crime and the fault element, or mens rea, mental aspect of the crime. We're going to codify those general principles to start with. And that sounds like a reasonable thing to do, because common law has found these concepts elusive and difficult over many years. We all know that the appellate judgments have struggled with concepts like intention and concepts like recklessness and concepts like knowledge and concepts like negligence and what role they play in the development of the criminal law. So they produced the general part. And that's all right. You can look at it, and there are provisions there that create all sorts of questions. For example, they tell us that the physical aspect of a case includes an act, and without wanting to get too semantic about it, the very word act conjures up notions of what is an act, to what extent must it be a willed act, a voluntary act, all these questions that immediately have to be determined, but they didn't exactly define or tell us how that worked. You've done the same thing in your Law Commission draft report of 1989, except you didn't do it quite the way that we did, but it's there in the general part. So most codes, not the Indian code interestingly, but most codes have a general part with these sorts of general principles of criminal responsibility right at the outset. And that was fine. As I say, it ran for about 25 pages and one could make sort of sense out of it in various ways. There are a couple of things in that attempted codification that were very, very bad indeed. One of them was that although we defined the fault element and the physical element separately, a very Austinian kind of approach to legal analysis, very rational, very much commended by academics in Australia at least. The actual way in which the provisions were said to work was one that was always going to cause terrible problems. For example, it said that not every physical element of a crime, where there might be, let's say, 2 or 3 physical elements, will necessarily have the same fault element. So you might have the fault element for a particular physical element as being intention, the highest kind of purposive state of mind, or mens rea, if I can put it that way. That would apply to one aspect of the physical component, but not others, so that there might be recklessness as the default position for other physical elements. Now, you can already see how enacting a provision of that kind is likely to work. Let me read you just a comment from a colleague of mine on the Federal Court of Australia. As I say, they don't do many criminal cases. They're just starting to do some now. This gentleman is an absolutely brilliant lawyer. He's a tax lawyer, company lawyer extraordinaire. He was doing his first criminal appeal, sitting in the ACT Supreme Court, and he'd done a criminal trial as well. And as I say, a gifted lawyer, truly gifted. He said this to me: I summed up to the jury on the criminal code offences of indecent and grooming communications under section 427 and 427A of the code a couple of weeks ago. I'm writing a reserved full court judgment in a Corporations Act appeal on a criminal provision. I want to say something more about the absurd and incomprehensible junk that all this is. There were 9 elements each with a physical and fault aspect to one of the offences I had to explain to the jury. I couldn't make any sense of it myself, let alone them. Fortunately, no one asked for a redirection. Now, that's the state that we have reached in Australia. Our original 25 pages of general principles were then followed up by what Glanville-Williams would have called the special part, a whole series of offences. And this started off at about 120-odd pages of special principles, that is, the actual substantive offences themselves. And it's now, at last count, 887 pages and growing exponentially. And I'm talking only about the Commonwealth Criminal Code, which does not deal with general criminality. It does not deal with murder, rape, the sort of traditional criminal offences. What it does deal with is a whole series of new offences which have come to light and become Commonwealth-based offences. So we have, for example, slavery. We have various United Nations type offences. We have terrorism, which has grown exponentially, of course. We have the drug offences that have now ballooned out. We have a whole series of corporations type offences. This is just expanding at a rate where you now need 900 pages just to look at the substantive federal criminal law, which is a small part of our criminal law. If you think that the non-codification position is any better, you're wrong. In my state, Victoria, where we have not codified substantive criminal law, but we have a Crimes Act, a central act, which sets out the offences by way of consolidation. When I started studying law 50 years ago, as I say, that Act was about 130 odd pages. At last count it was 680 pages and growing at a pretty rapid rate. Now, it's not codified, but it's all statute-based. The only common law offences we have left in Australia are murder and manslaughter, pretty much. Everything else is statutory. But it's all found in the Crimes Act as far as substantive criminal law is concerned. But we haven't stopped there. We have codified left, right and centre. We have a Uniform Evidence Act in Australia, which is a code. So our law of evidence is no longer the common law of evidence. Instead of having a hearsay rule based on common law, we have a statutory form of hearsay rule, which is all but incomprehensible. Instead of having a similar fact doctrine based on striking similarity or whatever test one wanted to apply at common law, we have sections of the Act that have given rise to enormous difficulty dealing with what are called tendency and coincidence evidence and matters of that kind. And these are grist for the mill as far as our court is concerned, because we get dozens of appeals arising out of the interpretation of these particular sections. So our law of evidence is completely codified. In Victoria, our law of criminal procedure is completely codified. We have a Criminal Procedure Act. So we don't rely on common law at all in relation to criminal procedure. Our law of bail is codified. Our law dealing with warrants is codified. Police powers codified. Everything is codified. And has it made the position any better? Well, I heard Professor Ormrod in a very persuasive talk last week speak about how the very process of sentencing in England and Wales is now so complex that about a third, I think he said, of all appeals which are allowed on the basis that the sentence imposed was technically invalid. We're not talking about being too high or too low, which is the usual kind of argument, but technically invalid. That there's an illegal, invalid sentence imposed because of the sheer complexity of the steps that have to be followed by a sentencing judge. The position's about the same in my state. We have codified the law of sentencing. We have a Sentencing Act, 1991. It started off at about 100 pages. Last count, I think it was about 450 odd pages. And it grows all the time. And it is drafted in language that is so prescriptive that one almost can see the draftsperson saying, what if this sort of odd situation emerged? We have to have a section dealing with that. And we can't possibly leave it to the judges to work out what to do in this situation. Let's tell them. And we'll deal with it by enacting a whole series of complex and convoluted provisions that will tell the judges exactly what they must and must not do. And so the Sentencing Act does that. We have the unique distinction in Victoria, I think, you'll correct me if I'm wrong, of having recently had our Court of Appeal strike down a statute, not on constitutional principles, but on grounds of incomprehensibility. We had a provision which was drafted at the behest of the former Attorney General of Victoria, who was determined to ensure that people went to jail for longer. So he created a doctrine or an idea called baseline sentencing. And the idea of baseline sentencing was a bit like mandatory minimum sentences, but he wouldn't use that language because there'd been a lot of criticism of mandatory minimum sentences. So he said, in effect, and the statute provided, that a judge, when sentencing for a baseline offence, had to work towards achieving an object, the object being that the median sentence, you all know what a median is, I assume, a median sentence for this offence in the future will be 5 years. The median. So you have to work towards that median. Problem is that he didn't provide any basis on which the median could be calculated. So you didn't know whether to go back 2 years or 3 years in order to find out what sentence would have to be imposed to achieve the legislative intent that you work towards median sentencing. And it was struck down, first time I've ever seen it. Struck down as incomprehensible and unworkable. And sentencing is par excellence one of these areas where every politician is an expert. Every member of the community is an expert. Everybody thinks that it's really very simple. Sentences are too low. We ought to increase them. How do we do that? Let's enact some mandatory minimum sentences or something of that nature. The complications are absolutely mind-boggling, let me tell you, when Parliament does that sort of thing. I recently sat on an appeal involving a new kind of sentence. This was for an offence of causing serious injury in circumstances of gross violence. The words "in circumstances of gross violence" were inserted into the statute. And we had a definition of "in circumstances of gross violence." That's all right. It meant that 2 or more people were involved. There was a measure of planning, and so forth and so forth. But the consequence was that the non-parole period, the minimum period that had to be served before the person could be eligible for parole, had to be 4 years for that particular offence. Now, this caused great consternation in the trial division of our courts, the county court in particular, for all sorts of reasons, because there was an internal inconsistency in the Act. The Act said that when you imposed a sentence of more than 2 years, you had to get a non-parole period fixed. The Act provided that as far as community-based orders or other orders were concerned, they could only be imposed when sentences of less than 2 years were provided. All of that meant that judges were artificially imposing sentences to get just below the 2-year sentence that would allow them to trigger this particular process. And so we were getting sentences of 23 months and 3 weeks regularly coming up from the county court, to which they could then attach the type of consequence that would enable them to avoid the need to bring in one of these gross violence offences. Well, again, it requires a lot of unscrambling, and there's 2 of our judgments extend over 100 pages on how these provisions can be made to work. The consultation that goes into changing sentencing laws is very, very limited indeed. We find, for example, that as far as sentencing is concerned, our statutes are amended about 20 to 30 times a year. Every time a problem arises and it's thought, thank you so much, we really do need to deal with this particular problem, we get a spot check amendment to the legislation. And of course, as you know, and I think as Professor Ormrod made the point the other week as well, when you have a spot check type method, incremental method of changing the law, you get transitional problems all the time. We have had terrible problems with even concepts that ought to be terribly simple. Self-defence, for example. What could be easier than self-defence? It was fine until Parliament decided to tell us what it was in statutory form. They decided, at the behest of certain pressure groups, to get rid of provocation, for example, because provocation was regarded as a defence that was available to men. It was gender biased and so forth. So we got rid of provocation. We're the only jurisdiction, I think, in the Western world that no longer has provocation as a defence to murder. But they introduced instead something that was called defensive homicide, which also came to manslaughter, which was intended to operate in favour of women who were being badly treated by their spouses and killed in those circumstances. Problem was that in 23 of the first 24 cases where defensive homicide arose, it was invoked by men in place of provocation. Again, I don't debate the policy wisdom of all this, but there are always consequences and unintended consequences that arise. Rape, our laws of rape and sexual offences in Victoria are extraordinary. When I studied the law, a small chapter of every criminal law textbook would deal with sexual offences. These days, our trial courts deal with almost nothing but sexual offences. We don't even bother with prosecuting fraud because it takes too long to investigate it. It's too hard. The prospects of getting a conviction absent a confession are fairly dim. So what do? We prosecute what I would call old sex cases. And when I say old sex cases, I mean old. We have a lot of prosecutions going through the County Court of Victoria, which is our trial court, going back to the 1960s, 70s and early 80s. These are 30 to 40 to 50-year-old offences. They're not rape perhaps as you would understand it, because in England and Wales, rape means rape, basically. in Victoria, rape does not mean rape. Rape includes what used to be called indecent assault, for example. Digital penetration is rape in Victoria, so are various other forms of penetration. Now, again, that's a matter of policy and debate and so forth, but it's had the most profound consequences. So we get very old cases being conducted all the time, having to work with substantive provisions, and you all know how hard it is, don't you, to enact provisions that deal with concepts in complex interaction of human beings, like consent. It sounds like a simple notion, consent, but in the context of male-female or male-male or female-female relationships, consent is a very elusive and slippery concept. What does it mean? What mental state must an accused have in order to be convicted of rape? We decided to legislate this, and we did it in all sorts of odd ways, and it produced, again, case law by the score, so that rape was defined as meaning absence of free agreement. Yeah, that's okay. And then there are a series of situations which were said to indicate an absence of free agreement. That's okay. And then we get to the mental state of the accused, and the question is there an objective component in all this? You all remember DPP and Morgan back in 1976, when the House of Lords outraged the entire English populace, or a good part of it, by saying that a man who honestly believed that a woman was consenting was not guilty of rape, even if his belief was unreasonable. Well, we're still having that debate. We now use terms like reasonable belief. We put that into a statute. What does reasonable belief mean? A person in the position of the accused, did a person in that position reasonably believe? And so one has to work out what is meant by, did a person in the position of the accused, what characteristics do you vest the accused with when you talk about a person in the position of the accused? Do you invest age? You certainly don't invest alcohol, because voluntary intoxication is specifically excluded. I could go on, but I think I've made the point sufficiently just to say that we have a very high appeal success rate in Australia. It's not because our judges are any worse than your judges, I would respectfully say. I think they're probably on a par. I don't say they're better, but I think they're probably on a par. It's not because our appeal judges are any more tender towards the rights of people who've stood trial and overly susceptible to allowing appeals and so forth and so forth. But our appeal rate is probably, success rate on convictions, probably about 30%, which is pretty high. It's probably about 15%, 20% on sentence, which is pretty high. When I was practising in this area, acting for accused persons, if I won one case in 10, I thought I was doing brilliantly. If I won an appeal against conviction, it was a miracle. But these days, these cases have to be tried again at vast emotional cost to victims, at vast expense to the community, bringing in juries who have to be brought back for lengthy and unnecessary trials, in part because the criminal law is and has become so complex. Now, I don't care, frankly, what the tax lawyers want to do with their tax laws. I know people say tax law is too complicated, we should make it friendlier and easier and more comprehensible. Frankly, I don't care. It's a business of specialists who work in that particular area. They'll work their way through that kind of problem. The same with corporate law, the same with cartel or anti-competition law, the same with intellectual property. You can have all the refinements you like in your statute and do it impeccably. But with the criminal law does not work that way. If you start with the proposition that the people who need to know about and understand the criminal law are, firstly, I suppose, those who are minded to do something which may or may not be criminal and want to know whether they'll be breaking the law. That's a wholly fatuous example, may I say. When people talk about accessibility to code, I don't think people who are engaged in what we understand to be serious criminality are all that concerned about reading the terms of the code. So forget that. But it's something we pay lip service to. But rather than that, bear in mind who are the users of these criminal codes. in my country, and here I'm sure as well, 95% plus of all criminal matters are dealt with by magistrates. And they're dealt with at great pace through the magistrates' courts, day in and day out. And they have to get an answer. They have to get an answer which is practical and correct and quick. Who else needs to know? Well, in serious cases, juries. If you allow your criminal law to become too complicated, too many elements, shifting elements, because somebody has thought up there's a great deal of symmetry associated with having this fault element associated with this physical element, and we'll switch it around and make it recklessness for this and intention for that, you are inevitably going to have to direct juries along these lines. And juries should never be required to go through this exercise. Juries should never be required to do anything other than answer questions of fact. It's as simple as that. Questions of fact carefully formulated by a judge through a question trail or a route to verdict or something of that nature. That's what our system depends on, and we're destroying our system, it seems to me. Judges can't sentence lawfully. Well, that's a catastrophe. Judges who have to make instant decisions on points of evidence during the course of a trial, because you don't have the luxury of saying, well, we'll send the jury away in most cases and we'll come back in 2 or 3 days when I've researched the entire doctrine of res gesta. We don't have the advantage or opportunity to do that. So I'll stop at that point. I've had my bitch, if I can put it that way, using an Australian colloquialism, about our system and the way it is not working. And I will say this, I'm not alone. As an ex-academic, I loved codification as an academic. I used to think, let's legislate. This is bad law. Common law is bad. Let's legislate. Let's codify. We'll have a uniform, clear code. A few years, a few more grey hairs, has taught me, be careful. Legislate with care. Embark upon this process with care. I'm not a great fan of wide-ranging codes that deal with everything across the board. I think that's a big mistake. I'd rather you take a particular area of the law, as you did with your Theft Act, which by and large has worked well. We borrowed it. We stole it. We copied it. And it's worked well. You've still got problems with it, and there are still issues about it. But that was a very good piece of codification. So I'm not opposed to codification. But I'm opposed to this notion of let's have a sweeping code. Let's set the Law Commission adrift again and give them a reference, and let's codify the whole of the law, criminal law. And we're not talking about just substantive law. We're talking about evidence, procedure, sentencing, substantive law. It's too big a task. It can't be done, and if it's done, it's not worth doing. So please get stuck into me, to use another Australian expression, and tell me where I'm wrong. Yes.
Can I start by saying thank you for the fascinating insights, and but I'm not going to say much more because there are various people here who are engaged with legislative drafting in all sorts of ways, so I'm sure they're going to have a lot to ask you. Well, let's start straight on
Well,
in.
thank you very much for an incisive explanation. It seems to me that it would be necessary to have an up-to-date commentary produced that's available to judges and magistrates, giving the latest statutory interpretations. Does such a thing exist?
Oh, yes. We are obviously, in fact, we have a number of bodies that are responsible for educating judges. The Judicial College, for example, there's a Judicial College of Victoria and a National Judicial College. It produces commentaries of exactly the kind you're talking about. So if you go onto the website of the Judicial College of Victoria, for example, you will find that there is a jury directions manual which goes through each of the substantive offences and the latest law on the subject. The problem is it goes for about several thousand pages, and it's intended to be comprehensive. So we do it in two ways. We do the executive summary for the judge who doesn't have time to read the lot, and we do the full exposition for whoever it is that wants to write a PhD treatise on this particular branch of the law. So yes, we're conscious of the need to educate judges, but many of our judges are appointed without ever having practiced criminal law, and they're thrown into the hardest trials there are. You know what the hardest trials that we do are? Old sex cases. Murder is easy. There's a a killing, there's a victim. The victim can't give evidence, but you can work out whether the accused did it or did it with what particular intent and so forth. Old sex cases, which dominate our courts, 80% of our criminal trials are old sex cases in my state. They're hard, they really are. Conspiracy, drug cases, they're hard too. As I say, we don't bother prosecuting fraud anymore. We've given up on that. We've done something quite remarkable. We now have a system where we have what are called pecuniary remedies. These are methods of dealing with fraud which are civil in nature but carry a penalty. So that, let's say that you have a corporations offence or you have a cartel offence, you face the possibility of a civil application for a pecuniary penalty. It can be quite sizable. It could be millions of dollars or tens of millions of dollars, but it's not a conviction. It's not a criminal offence and nobody goes to jail. So this is another feature. The regulators in my country have been inclined to use these pecuniary remedies rather than going for prosecution in front of juries. We don't have long fraud cases of the kind that you have here. We don't have a serious fraud office, which I think still exists here. I remember it when it was set up. But we shift these into a different realm. Again, I'm a strong critic of this. Having spent most of my working life advising miscreants who've been involved in defrauding the public in various ways, the only thing that ever concerned them was the possibility of going to jail. I know that. And once they knew that all that could happen is the company would be forced to pay some sort of fine, it was all right. It's... I've lost the thread of your question, I'm so sorry. But yeah, the commentaries are there, and they are exhaustive and extensive, and judicial education is regarded as a very important aspect of the work we do.
I wonder, given how important magistrates' clerks are, whether there's a more succinct version for them and for magistrates.
The magistrates deal with matters at the rate of 80 to 90 a day. I kid you not. There's very, very rarely a contested case that occupies any period of time. It's not such a problem because there is a right of appeal. And the right of appeal is by way of rehearing de novo. So you can go to the county court if you've been convicted of some summary offence in the magistrate's court and have the whole thing heard again, and at that point it becomes more serious, if I can put it that way. But the throughput in the magistrate's court is it's a conveyor belt. Get through it, get through it, get through it, and most of them are pleas of guilty anyway. So yes, people do need to know what branch of criminal law they're applying and what the basic rules are, but it's done in a very, very rudimentary kind of way.
Judge, what are you suggesting or proposing? Do I understand that you're in favour of codification, but you want it in specific areas, you want it short, you want it simple? Is that
does that sound like such a bad series of ambitions? Yes, I'm not proposing a return to the glories of the common law. I still have fond memories of the distinction between larceny and larceny by a trick and embezzlement and all that sort of learning. No, I'm saying that we need to keep the law up to date, and codification and law reform are essential exercises, but they have to be done properly and carefully and with a view to understanding for whom the law is being drafted. And this calls for different legislative technique. It's wrong. Let me give you let me give you an illustration. Our sentencing laws, for example, in my state, insist on drawing a distinction between the bare offence and the offence with aggravating circumstances. And you get potentially more if you commit the offence with aggravating circumstances. This just is completely unnecessary. Why do we do it? It means that the person is charged with the offence with aggravating circumstance and runs a trial which might go several weeks saying, I didn't commit the offence with aggravating circumstance, I only committed the bare offence. That's my defence to the charge on aggravating circumstance, because I want to avoid a mandatory minimum penalty or a greater exposure. So we run unnecessary trials. Why do we draft, for example, provisions like our money laundering laws in our Commonwealth Code? We have 6 money laundering offences depending on the amount money laundered. It's over $1 million, between $500,000 and $1 million, between 100,000 and 500,000, between 50,000 and 100,000. What the hell are we doing? What's the point of it? Why can't the judge be trusted, if there is a conviction for money laundering, to work out what the appropriate penalty is given the amount that was laundered? Why do we go through this particular exercise? Why did we create an offence of aggravated burglary? We never needed it. The offence itself carries 20 and the aggravation is 25. What's the point of it? Why does Parliament insist on going on in this highly prescriptive way, indicating that the drafters think that the judges are fools, enacting legislation of the kind that I illustrate? You must impose a sentence that's appropriate in all the circumstances. Thank you very much. And I could give you many more examples of that kind. When Parliamentary Council draft, it seems to me, there should be the most intense and closest consultation with the profession, with the judiciary. Judiciary not so that judges can get immersed in policy. It's not our role to do so, and we endeavour as best we can to stay out of that exercise. But there should always be a regular ongoing consultative process with senior members of the judiciary, trial judges, appellate judges, so that things are run past them and input can be gained as to how these are likely to work in practice. What is the upside, what is the downside of this particular proposal? And there should be a moratorium on amending legislation. If it's enacted, it should be allowed to stand for at least a year without a single amendment, no matter how bad the provision is.
Well, we do, if I may say so, most of this in England, but the problem is criminal law is of interest to the public. It's got a very strong political implication.
Of course it has.
And politicians are very much...
And they should understand, however, that at the policy level, that's important. We have a democratic system and democratic values are at play here because we're talking about individual liberty and rights of victims and so forth. But the actual techniques of the criminal law are not for amateurs. Everything fits together in a different kind of way. You create a kind of...
So you haven't controlled your politicians in Australia any more than we've controlled them in England?
No, our politicians in Australia are hopeless in this area. Completely hopeless.
Judge, can I just build on that about
Yes.
politician discipline? Professor Aldenroth the other day was quite concerned that in the context of the sentencing code, that once it gets into the parliamentary process, it would go through, query whether it would ever be a hostage to fortune for all sorts of other agendas. But thereafter, both government and politicians generally might want to amend sentencing law and not to do it to the code, but go off on a frolic and do it quite separately and have yet more layers of legislation on top of that code. Has that been an issue with your individual code?
Absolutely. It's the bad man theory of law. You get a bad case and instantly there's a legislative response. We had a very bad case, a shocking murder a couple of years ago by somebody who was released on parole and shouldn't have been released on parole, quite plainly. So we tightened up the parole rules, making it almost impossible now for violent offenders to get parole. Of course, that's going to have... You have to be satisfied on the parole board now that there is a negligible risk of the person reoffending in the case of a violent offence before they're granted parole. Of course, this means that we have to build more jails. Our prison population is expanding exponentially as a result of this. One understands this, but there's always a need to stand back and understand the pros and cons and at what level the change should be made. You don't necessarily respond to a case where somebody got parole, went out and killed somebody, by saying nobody will get parole anymore. And that's the kind of knee-jerk reaction, unfortunately, we get. And what was said before is quite right. Every politician regards himself or herself as every member of the community. You can walk down the street, they'll tell you sentences are too light. The judges are not doing their job properly. They live in ivory towers. They don't know what they're doing. Interestingly enough, we have some research in Australia very valuable research. I'm a great believer in evidence-based research, evidence-based analysis, where juries who had sat on particular cases were asked by university researchers what sentence they would impose, putting to one side before the judge had sentenced. Almost invariably, the juries would have imposed lower sentences than the judges did. So it's counterintuitive, but the truth is our sentences have gone through the roof. We sentence at a very high level now in Australia, really high, except in relation to white-collar crime where we don't bother. But in relation to violent offences and so forth, our sentences are huge. When I started practising in the criminal law, the standard rape sentence was 4 years with a non-parole period of 2 years. The standard rape sentence now would be 8, 9 years, quite clearly. Culpable driving, which is causing death by reckless driving or whatever you call it here, that was an offence for which you could keep somebody out of jail. You could actually do it in an appropriate case. Now you're getting 7, 8, 9 years for that offence. Murder used to carry 17 with a 13 on the bottom. That's 13-year non-parole period. Now you're into the 20s. Everything has gone up, but the perception through the tabloid press and through the populace, unfortunately, is at odds with this.
Is the good news, though, that the amendments are actually made to the existing code in legislative terms, rather than having bolt-on extra bits of legislation?
When you have a code and you amend the code, and you amend it as the years go by, different parliamentary draftspersons have different styles of drafting. And once you have one set of provisions that use one style of drafting and a later set of provisions that use a different style of drafting, some bright barrister is going to come along and say this was a deliberate intent on the part of the Parliament to vary or depart from the earlier case law that is built around the earlier sections and so forth. So codes are not necessarily ossified in the way that the straw man was set up, that, you know, if we have a code, it's ossified. Although if you look at your 1989 code now, it looks very old. It doesn't cover most of the contemporary offences with which we're concerned in this community. There isn't a word about terrorism in that code. There isn't a word about explosives or espionage or public order type offences, very little. It's a traditional code, but 119 pages compared to our 887 of federal law and 20,000 if you want to put all of our statutes together, covering a whole range of criminality.
You describe, I think quite correctly, actus reus and mens rea as being concepts. I would ask simply that, can one codify concepts?
We're dealing with language, and we do the best we can with the law works through language. And the language can never encapsulate the complexity of the psychological processes that are involved. Take a simple concept like intention. I don't need to tell you. We can have shades of intention, debates about the difference between purpose, certainty of consequence, foresight of probability of consequence, gradations of a mathematical kind. You know, you can write a chapter just on that one single word, intention, and it's been done in the past, and the philosophers have done it. But what's the alternative to the use of language, words, to try to encapsulate what it is?
I mean, what I'm suggesting is that perhaps that those ideas then, really, since it's virtually impossible to simply describe those concepts in language that's accessible, that it has to be left to the wisdom and experience and education.
And that's exactly what the Indians did when they adopted the Stephen Code. They said, no thank you, we won't have the general part. We'll have just a series of provisions defining offences and what the elements of each of the offences are. The task of trying to permanently describe these psychological factors that are at play when we talk about fault elements and so forth is beyond the human capacity in the use of ordinary language. And as best we try, we talk about plain English. Let's draft in plain English. No such thing as plain English. There's archaic legal English, and there's language using non-legal terminology, but which will always be pregnant with ambiguity and uncertainty that will always have to be construed, and there'll be no right answer in many cases. And we, sitting on the Court of Appeal as I do, we do the best we can. We use canons of construction. We go to Benyon, we go to the text, and what do we do with them? Well, we find that for every canon of construction leaning in one direction, there's a canon of construction which moves in the equal and opposite direction, and we can come to the conclusion we want to. We can do bottom-up reasoning or top-down reasoning. We try, as best we can, or at least I do, to work my way through the problem and work out which is the best solution, the one that best accords with what I impute to Parliament, because that's an artificial construct in itself. Parliament never gave any thought to these matters at all. If it had, they wouldn't have drafted the provision in these terms. So I'm sorry if I sound very cynical. This is the product of 50 years of attacking legal reasoning and then sitting on courts where day in and day out I have to work through this, as my colleague described it, garbage, going from section to section. I remember a case where, when I was in the federal court, we had to work out how a person was entitled to a particular pension, Social Security Act. You'd think this is an act for poor people who should understand where their entitlements come from. We had senior counsel appearing for the Commonwealth government. It took senior counsel 3 hours of extensive argument to take us from one part of the act to the other. This is an act that runs for 3,000 pages, let me tell you, to tell us and explain to us the source of the power to grant this particular pension. The reason, because instead of having 2 or 3 pensions, we had several hundred pensions, different ones, with little technicalities attached to each of them. Now, Parliamentary Counsel, get your hands off the legislation. Make it clear and simple as best you can. Try to persuade your political masters that when you've done the job, leave it alone. Don't try and improve it when it goes back into Parliament.
On those words of caution, I should say that the session is being recorded and will appear on the website, although if you might want some editorial control.
No, I'm perfectly... I've said these things before, and my best friends in Australia, some of my best friends are parliamentary drafters. They know my views about modern legislative drafting, and I'm perfectly comfortable. They can't do anything to me.
Always a good position to be in. I should say, some of your words about instructions to judges being incorporated in legislation remind me very much of the way the university is managed, where people like me are told exactly what to do in every circumstance, usually by the finance division, I should say. Thank you very, very much for a fascinating insight, and thank you everyone for participating. And I should remind you of the evening lecture on the 21st, if you have the opportunity to come on.
Can I just say this? I'm here until the middle of December. I'm occupying a corral on the 2nd floor, and if anybody wants to come up and take the discussion further or talk about anything at all, I'm very happy to make myself available to do so.
That's very kind. Thank you.